How's everyone doing?
Great.
Fantastic. So, as I was talking with Dr. Larkin a moment ago, up until now, most of your life has had to just kind of go along with the flow of what's being presented to you by the health system, by the medical school, the any document that's been presented to you. For the most part, you haven't had much say in what your options are. And what we're going to talk about today is the specifics of when you are wrapping up your time, whether it's in residency or while you're in fellowship, you will most likely be presented with a contract through your future employer that will be between 10 and 30 pages long. And you'll have to get some help with it in terms of legal background, legal perspective, since you probably haven't practiced law before, you're not an attorney, and you have to navigate the difficulty of all the ins and outs within the document that can cause trouble for you in the future. And we'll get into the specifics of what that is. But the good news is you will have say, you will have options. The contracts that you'll be presented are negotiable. Most of the time when we are reviewing contracts, we find that employers are willing to make adjustments and make changes. Oftentimes they're out of date and need to be updated. So look forward to that point in time where you will have say in what the structure is, what your options are, what you're paid, schedule, things like that, that will come into play for you. So with that, again, my name is Justin Nabity. I am the founder of Physicians Thrive. We are an advisory group based out of Nebraska, and we've been serving physicians across the country in all 50 states, all specialties, all practice types. And we are a part of the Larson Financial Group Network based out of St. Louis. And we love helping physicians in this capacity because it all started back when one of our family members got taken advantage of by a bad contract situation. They had a contract presented to them. They got legal counsel to help them with it. And then they were working with them for a little while, but then things changed when there was some issues with the practice and the employer asked them to essentially take a pay cut for a period of time while they were going to restructure. And because they had worked there for a period of time, they had a relationship with them, this physician was the most respected specialist in the area. They had no reason to second guess or to question that this new handshake sort of structure would be something that they could rely on. After some time went on, as a part of the deal, they were told that because they weren't getting paid according to this restructuring, that would be giving them credit toward what their buy-in would be as a owner of the practice. This was a private practice, and records weren't being provided. They kept on asking for these records. Eventually, they said, "I can't wait for the records anymore," and it was a bad situation because what ended up happening is the physician had to sue the employer to get access to the records, and it was the last thing that he ever wanted to do. This is somebody who, if you met him, you would know that he's the last person to want to get into a confrontation with anybody. And the good news is that he did win the suit. He found that there was over $200,000 owed to him, and that was the only way that he could get access to the records of what he was owed. And so he had to go through the process of discovery and collecting all that information. And he did win the case. It took multiple years to collect on it. He didn't collect everything. And there were some other restrictions also involved in that. And so our company, Physicians Thrive, was started because we had heard that turnover was high among physicians in the early years of practice. And, whether that's 70 or 80% within that first contract, that was one thing. But we wanted to go put out some feelers to see, is that truly the case? After looking into it and hearing this personal story from our family, it was like, okay, this is really a problem. So our group, as a financial planning organization, we decided we need to make sure that at the very beginning of everything that a doctor does, we want to make sure that they have the right intel when it comes to their compensation, getting paid fairly, but then also getting access to the right kind of legal counsel. So that way you get access to a attorney who's a labor lawyer, somebody with experience in your state, your specialty, and your type of practice. Those are all the kind of criteria. So when you're thinking about who is qualified to help you. When you get to that point in time where you want to have somebody help you with your contract, you want that criteria to be involved. You do not want a general business attorney, a family law attorney, someone who's not specific to your specific need. And a litigation attorney is not who you're going to want to have involved at this initial step of the process. Plus, these types of attorneys aren't going to have the compensation data that you're likely going to want to have. And so there's a number of criteria that you want to use. But before we jump into the specifics of the material for today, are there a few of you that could share maybe some specific things that you're going through right now or that you're thinking about that we can make sure that we're going to tackle today as a part of this presentation, something that's maybe specific to a contract or an interview, or maybe it's a specific state that you're considering, trying to decide between this state or another state. Like, what are some things that you're thinking about right now that would be helpful to make sure that we tackle that as a part of the topic today?
Yeah, so I was thinking of doing locum positions after graduation. I know that there's like recruiting companies and specific like locum companies out there, but if you have any information just on starting that process and like what to specifically look for with the locum position, that's helpful.
As far as like what the position, like the expectations, or if it's a good group to work with for locums?
Yeah, like what would be a good group to join, specifically like dealing with locum jobs and
Okay.
look out for.
Yeah.
Would you guys have more information about how to start the process of becoming an LLC after graduation to allow?
Yeah. Yeah, that's good. Yeah, so if you're thinking about working locums, you don't necessarily have to have an LLC. I know that wasn't for the same purpose the question came up, but we'll talk about that. The entity structure. We are big fans of working in the capacity where you get paid as a 1099. And maybe that's something that you've heard about before or not, I'm not sure, but it's very tax favorable for you to be able to not receive W-2 wages if you can help it. Now, many of you, you'll get offered a contract where you will work as an employee, and so you won't have access to that. And most don't have access, but if you can work it out with your employer or the group that you're going to be working with to get into a 1099 situation, which most locums are 1099, then there are several things that you can do that can help you keep more of the income that you're earning, allow you to do more advanced things for retirement planning. So those are going to be some things that we can definitely touch on. What else you guys want to talk about?
Sign-on bonuses for like loans, maybe?
Yeah. Good. Yeah, I love that question because there are several of you that will receive a contract that has no sign-on bonus included in the package. And one of the things that we'll discuss is the negotiation strategy. Employers don't start out with their best offer, and sometimes they leave out the signing bonus, but we're seeing more and more signing bonuses are becoming more common. When we were doing this about 10 years ago, I think the statistics said that it was about 25% of the time that signing bonuses were included, but now we're seeing it's much higher than that. And so by asking for the right amount, having the right approach to it, chances are that you will be able to get it included. And many times you can even get an increase in the signing bonus. And so definitely something that we'll touch on. So what I'll do is I'm going to go ahead and launch into the material. As I go forward, feel free to stop me as we're getting into it. Jump in with a question. I'm happy to stop and discuss whatever it is that you want me to expand on in that area. And then we'll certainly have time at the end as well to go into some more questions. Is that coming up for you?
Yeah.
Okay, awesome. So what we're going to touch on today is the importance of getting the documents that you'll be receiving reviewed, what you can do to negotiate. We'll get into common areas of the contracts that usually cause the most trouble for you, which is really the key thing. We'll get into what you can do to negotiate, and then we'll also talk about other resources that are out there that you can access. when you receive your first contract, as you've received potentially your residency contract or your fellowship contract, these will be between 10 and 30 pages long, and they will be drafted by a lawyer who the employer has hired. And what you have to remember is that this contract is there to protect the employer's best interests. They're going to be laying out what they're expecting of you, as well as what they should be providing to you. And so the key thing to remember is that the contract you sign may have some missing pieces in it. If something's missing from it, you have to be able to locate it. You have to be able to find what that is, and then either understand and know that it's there, that is a potential problem, or you have to insert language to close that gap. Because when these lawyers are working for the employer, they're usually paid by the hour, and they're not going to leave something out by accident. If they leave it out, it's usually for the employer's best interests. So it's important for you to make sure you understand what might be missing, and if it's something that you're like, yeah, I'm willing to take that risk, or if you're not, then you've got to have language inserted and provide that to the employer and hopefully get them to accept whatever that is that you change the contract that should be for your best interests. What you'll find is that the contract will be broken into these core 6 areas. And whether you're doing locums or you're employed or you have your own practice, because maybe you want to do that. Maybe you want to open up your own entity and provide your services to an organization. You're going to want to specify the time expectation, the scope of practice expectation, as well as things like what are they going to pay you for that, call schedule, anything that's going to require you and obligate you to provide certain duties. Those things need to be laid out within the documents. That way you have a clear sense of what that is. And this is something that comes up a lot within the academic setting. You may find that they'll hire you and have you work for them for a period of time, and then they'll start wanting you to serve on committees and boards and take on other responsibilities. It might be that they want you to sign off as a director, overseeing some of your peers. Anytime that you have additional added responsibility on top of your already required duties that exist, it's important to make sure that the language is going to specify that. But also at the same time, want to make sure that the compensation is going to be appropriate for you for that time. We've seen many cases where there's been burnout issues where because they've asked them to take on more and more responsibilities that they're having to take an additional 2 hours after the work schedule to do charting and whatever else it may be. So it's very important that you have a clear sense of this. And some of the positions that you pursue, they might be something where they say, well, we'll have you work Monday through Thursday, and then we'll give you Fridays off. And maybe they're telling you that Fridays will be off, but maybe the document doesn't actually specify the protection that you need to have that off. And so anything that the employer tells you, even if they say to you that it doesn't need to be in the contract, if it's something to do with the expectations and the amount of scope of practice or the time, you absolutely have to have it in there. Because if there is a situation where maybe they have a physician who leaves that's a part of your team, or there's some other issue that takes place, or they open up a new location and they want you to now go work 2 locations or 3 locations or 4 locations, all those things can come into play and it can affect your ability to perform at the level that you want to perform at. And the compensation section actually can be affected by this significantly, because if you have a lot of downtime because you're bouncing from location to location, that can affect your productivity. And more, your contract, if it's not going to have a productivity provision at the beginning, it will have one after that initial term is over. And the term of the contract is usually 1, 2, or 3 years. Rarely do we see it go beyond 3 years. Yes, it is possible to have a 5-year contract, and that can be good for you. It really depends on if you're able to set your compensation at a level with, inflation adjustments over time. Are you still going to be getting paid fairly over that time frame? And maybe you want that security to be there for a longer period of time, especially if you're going to be going to a remote area where it might seem like it's more risky if you're going to take your whole family there and get the kids in school and stuff like that. So it's important that you have those aspects taken into account, because if the language is not appropriate, then that can cause issues for you at the time where they want to make a change with your duties. Let's talk about the compensation for a second. Where would you go, or what have you done so far to look up what's a reasonable compensation for you, whether it's going to be in GI or in nephrology or some other subspecialty, or if it's just going to be in internal medicine as a hospitalist? What would you say would be some places that you can go? Any ideas? Google, yep. And so what would Google provide to you if you did some searching, you think? Yeah, so I mean, there's definitely going to be some free options out there, like salary.com, ZipRecruiter. You're going to find that there's groups that are trying to provide compensation data for every occupation, and they have a sliver of it that they'll try to comment on for your industry. What's the issue with that database, though, or that data set?
They're not accurate.
Yeah, it's like how many doctors, how many gastroenterologists have submitted data, or are they referencing, and how old is the data? And there needs to be a certain number of them. And on top of that, what about your state? Or what about the region? Or what about the specific type of practice that it is? So this is where you're at a real disadvantage with employers, because employers, if they've been around for a number of years, they know what your production is. And one of the things that we're really passionate about is if you look at healthcare from the beginning to where it is today, things have changed drastically. Like the last 40 years, it's weird. It's like, how in the world did it change so that way doctors don't get to decide what's best for the patient? Why does the insurance company or the pharmaceutical industry, why do they get to call the shots on what's best for the patient? And so over the last 40 years, we've seen the erosion of decision-making, the erosion of control, the erosion of leadership within healthcare. Did you know that only 5% of physicians are in the seats of the leadership roles within health systems? 95% have never been through medical school, have never been trained, have never actually provided patient care. So it used to be that there was 5 physicians per administrator. And you fast forward to today, and there's 10 administrators for every 1 physician. And so what's happened is this healthcare pie, you've got about $5 trillion worth of money in healthcare spending. And if you had to guess what percentage of that goes to physicians, what would you say?
Someone said 6%.
6%? Man, you're good. Yeah, it's only like 7 or 8%. It's a tiny sliver. And if you think about the professional athletes, they actually decided to, because they were getting taken advantage of by the owners of their teams, they decided to form a union in order to get their voice back. And that's essentially where we're at today with physicians, is that it's gotten so bad where only 7 to 8%, and you are the star player on the field. Healthcare exists because of you. And so when it comes to compensation expectations and what's your fair market value, it's important for you to access good information. Have any of you heard of the organization called MGMA? How about like Sullivan Cotter or AMGA? Not yet. So these are groups that are more, they're better than like the typical like salary.com website where they may have some data for you. But the issue with these groups is that they only represent about 20% of the marketplace. Only about 20% of doctors are participating in submitting information to them. And so it's still not really a good representation of the data. And it's always going to be last year's data. It's never this year's data and then the data going forward. And so what you're going to want to do is, if you remember one thing from our talk today, you want to make sure that you take away this. If you can help it, and maybe you can't control this, but it's best for you to get between 3 and 5 offers. Do enough interviewing with employers that you can get access to that many places that want to hire you. This will literally make a huge difference for you in terms of how confident you are willing to be. And I say that because we have physicians that contact us every day that want help with their contracts. And many of them will say, oh, I'm fine with the compensation. I think the compensation is good based on what I've looked into. And when we take a look at the data, what we find is that it's 10% below market. It's $20,000 less than the employer would be willing to pay, or 30,000, or 75,000. We just had a contract that we negotiated for a client recently, and we got them a $75,000 improvement. 75,000. And this came from a client who's like, I don't care what happens. If the employer is not willing to give me what I want or not willing to play ball here, I'm willing to walk. I'm willing to pursue something else. I have other options. And so she was a lot more aggressive and willing to even potentially have to say no to it because the employer was not willing to provide what they were looking for. We have others that come in and they're like in between, saying I'm comfortable with the compensation as it is, or I want to do whatever I have to get the numbers to improve. So there's a whole range here. But think about this. Are you somebody who is willing to just get into the awkward, even in the midst of the employer trying to tell you that you're worth less than you believe that you should be getting paid, versus the employer saying that they think that you should be getting less? There's this back and forth of you trying to basically say that the number should be better for me. It's like, and then what do you do when you ask the employer for an improvement and they say no to you? Then what do you do? So whatever it takes, like I said, getting multiple offers is key, because if you see some variety of what is being provided, you'll have more confidence to ask for something than you would otherwise if you didn't see what else the market has out there. And if you only have one contract in hand, don't worry about that. You can access surrogate offers through us. We have all kinds of contracts. We've done tens of thousands of contract reviews over the years. And all the ones that we have that are current, we can reference those. We're not going to provide, obviously, the employer name or the client information, things like that, just like the type of practice, the general area of where it is. But you can reference those as a comparison and be able to use that for your thinking process as far as what's reasonable as far as what to ask for. Our average increase per year in a contract negotiation is $38,400. So there's a lot of opportunity, a lot of room to make adjustments. So that's the compensation area. And as you're thinking about your future, there's going to be a lot of variety between you and your peers here in this group, because you're going to pursue different specialties potentially that you'll subspecialize in. So those are going to be key things to think about. The benefits are an area that are typically not going to be negotiable for you. Everybody has provided those. There's labor laws that govern this and don't allow employers to provide special treatment with one employee to the next when it comes to these built-in benefits. They can do things for you like provide incentives or higher pay for you versus somebody else within the practice. But one of the key areas is going to be what happens to you if you can't practice anymore. If you have an injury or an illness that prevents you from being able to work. Do you know what happens in that case? Has anyone talked to you about that before? What kicks in? What is it?
Disability insurance.
Yeah, disability insurance. Has anyone talked to you about the difference between the employer provided kind versus what you would get individually?
A little bit.
So when you have the employer-based plan, it's usually provided at no cost. It's given to you automatically. What you have to remember is that the benefits are taxable. So you'll receive, call it 70% or maybe 80 on the high side, 80% of the benefit you receive. But here's the kicker. You normally have to be disabled to the point where you can't ever work again in any sort of environment. Like there's no workplace that can take you. So like you can't be a greeter at Walmart, you can't do teaching, research, consulting, administration, you can't do anything, because what they'll typically say is that once you've taken on an additional work job or additional occupation, that new occupation is going to be your primary field that you're in. So they may cover it for a year or 2 years in your specialty, but beyond that, if you have other income sources, they'll reduce your benefits or they'll turn benefits off. So It's key for you to get your own personal plan. We have several physicians who have gone out on disability claims before, and the employers are not, the plans that the employers have are not friendly. There's an Ivy League institution, which I can't name for the purposes of this recording, that got disabled. She was a GI physician actually, and she had an elbow issue, so she couldn't scope anymore. And it got into a fight with the employer. And that basically they were trying to negotiate her to cut her off of receiving benefits with the long-term disability plan that they were providing to her. And we had to basically negotiate a settlement with them because there were some nuances within the language of the contract that she signed with her benefits that allowed them to do this. And it was going to put her in a really bad situation. So this is like a top 5 Ivy League place. And so the main takeaway is that you want to make sure that you use your own personal plan in place. So that way you can collect it without having to worry about if the employer plan kicks in. And we had a client last year who was collecting $25,000 per month tax-free, and it was covering all of his medical bills. So he was fully covered. So if that's something that you haven't pursued yet, you can actually get the ball rolling on it while you're still in training. You can even do it in your last year of medical school. It's important that you get a plan that, if you can help it, if your health history is clear, if you don't have any health issues, to get a plan that's the most comprehensive, because those will be less expensive and will provide more benefits to you than a plan that is going to be provided with no health questions asked. Sometimes employers will have an option where when you leave the employer that you can sign up for a plan after you finish training. If there's no questions asked for you, then those are typically going to be on the higher side price-wise, and we'll have some restrictions for you because they're basically saying that it doesn't matter what your health status is, we'll take anybody in. So that's going to be a key planning thing from a personal perspective that you'll want to make sure that you're ready for, because you're not going to want to have a situation where after all these years you've invested into your training and education, that if you can't actually do the work, that you'll want to be able to get paid continuously ongoing without having any sort of restrictions to you. Any questions on that? Okay, so then getting into the termination section, this is the area that causes the most trouble we find for physicians. What the employer is going to do is that they're typically going to say to you that if you sign this contract, they can terminate you at any time for any reason. And if they do that, that you cannot stay in a certain area for a certain period of time. You can't do these types of duties. So think about that. If there's a 5-mile radius or a 10-mile radius and you're in a highly concentrated area, what are the chances that you're going to be able to find a different place to work that's within a reasonable driving time distance to a new place if things don't work out with your first employer? So it can be a big problem. And this is an area that is very negotiable. You want to be sure that you have the language changed. So that way it says, only in the event that you walk away from the contract voluntarily for no reason, or if you breach the contract, you do something wrong and you don't cure it. And the cure provision is key. When you are in a situation where maybe you did something wrong, or you have an issue with your license or something like that, you want to have a reasonable amount of time that you can cure and fix this problem. And do your best that you can to address that. But only in the event that the employer, if they terminate you for no cause or they breach the contract, then you should be free from these restrictions, right? Why would you be subject to these penalties that if they do something wrong, that you shouldn't be responsible for that, right? So this will probably be the biggest section of your contract. And again, the employers know that the likelihood of you staying there long term is going to be low because turnover is high in the early years. It's hard to know what you want. You get to meet them for a short amount of time, and maybe you know somebody that knows them, which is really key. If you're thinking about, like back to that question about locums, do you know anybody else personally that's working there? What's it like to get your assignments? Where are they going to send you? Is it going to be local? Is it going to stay? You going to stay in the area? Are they going to send you other places? Like, what type of support are they going to provide to you? Do they already have an established practice that's busy, that has the patient volume and the patient flow there? Are you gonna get paid regardless of what your production is and your collections are? So getting a sense of what the inside culture is like, it's hard to do that in the interview phase unless you know someone that's been working there for a long time. So that's gonna be key. But again, the employers, they know that the likelihood of you staying there long term is going to be low at the beginning. So if a contract is going to be terminated early, then you want to understand what are the ramifications going to be, what kinds of issues are going to pop up. And there's a big area like, for example, back to that question about signing bonus. That signing bonus, if you leave early, you may not be able to keep it. Chances are you may have to pay it all back. Or if it's a 3-year contract, you might have to pay back 1/3 of it because, or you're there for 1 year, let's say, for example, and you have a 3-year, you may be able to keep 1/3 of it and you have to pay back 2/3 of it because you haven't been there long enough. And that's an area where if the contract doesn't specify this, you at least should have the ability to have some earning rights to a portion of what you receive. It could be a stipend. Let's say you're going to do fellowship for 1 or 2 years. You could have the employer where you're negotiating right now. And I recommend this actually. If you have an idea of where you want to work, you can start getting the process going with an employer and start getting negotiation done now and lock in your contract before you're even finished with residency. If you're going to pursue a fellowship, for example, and they'll pay you $1,000 to $2,000 a month as a stipend to basically take you off the market, to say you're going to commit to us. And so while they're paying you for that 1 or 2 years, if you don't stay the entire term of the contract, they may require you to pay back a certain portion of it. So think about that. You know, things don't work out for whatever reason, and then you want to go somewhere else. What are you going to do? Well, you may have to deal with a huge payment on the back end that you're going to have to write to the employer. And on top of that, there might also be something, an issue with the malpractice insurance. Does anyone know what the 2 types of malpractice insurance are that are typically provided? Is this something that you've talked about before? Not yet. So there's 2 kinds. They're called claims made or claims based, or occurrence. If you get an employer to offer you a contract with occurrence based coverage, that's going to basically say that anytime that a claim occurs, they're going to cover you into the future. Doesn't matter when it pops up. If you're working with pediatric patients, then obviously that's going to be an even bigger risk that you want to make sure that you have this planned out. Most employers don't provide occurrence-based coverage. They provide what's called claims-made coverage, which means that you're only covered if you're working there when the claim is made. Once you leave, you're no longer covered. So think about that. You leave an employer, and then a patient that you saw a year or 2 ago comes back and files a claim against you. If you don't have a tail, which is an extension of the policy that was in place that was covering you when you were working there, then you could be personally at risk for that, whatever that claim might be. So we can talk about that some more toward the end if you guys want to dig into it. But that's a key area that you want to make sure that you have prepared for, because again, if things don't work out for whatever reason, and for most of you that will be the case, you want to make sure that you have a game plan. So that way when you leave, you don't have a $10,000 bill, a $20,000 bill, a $30,000 or a $40,000 bill. We've seen in the case where a client had a income guarantee. Actually, he wasn't our client yet. This was before us. He signed a contract that had an income guarantee in it. And this language said that he would get paid a certain amount for a certain period of time. And then if his production wasn't high enough, his collections weren't good enough, they would do an analysis and a reconciliation, and he would either get a reduction in pay as a result of it, or you have to pay them back. And so this was a high paying specialty. He didn't have a good experience with them in the first year. They didn't provide the support that he needed. And so his revenue wasn't there, his collections weren't there. And he literally owed the practice back $300,000 that he left. Imagine that, like the last way you want to have your exit be with an employer, have a situation like that. So income guarantees are tricky. It's not that you shouldn't do one, but you want to make sure that you know what you're getting yourself into and prepare for the understanding that along the way you need to make sure that you have access to the numbers and can get updates to see what things look like as you're going, so that way you don't get shell shocked by what could happen upon the reconciliation. So we talked about fair market value. There's a bunch of resources that we touched on a little bit. This is the thing, when you participate in one of these sessions, we actually will do a no-cost consult for you, so that way you can get the data for what's specific to you and your practice type and location. Usually there's a decent fee for this, but we waive that for the attendees that come to our sessions. And so feel free to reach out to us. We can go through some data like that. Your priorities are going to be key. It's important for you to take some time to write out from kind of start to finish, what do you want to make sure is the employer going to provide to you? And this gets into just lifestyle and your own personal goals and where do you see yourself in the future. It's one thing to look at that first year with the employer, but then it's also important to think about where will you be in 3 to 5 years? What are the doctors that have been there for a long period of time? What does their life look like? What is their compensation structure? And even doing some interviewing, talking with them to get a sense of what they're getting is going to be key. We touched on the legal counsel aspect of this, the type of attorney, experience in your state. They don't have to be licensed in your state. The only time that you really have to have an attorney licensed in the state is when you have a conflict going on, a specific situation where you're going to court. You absolutely have to have counsel that's licensed there. When you're doing transactional law like this, it's not required, but you want to have somebody who has a ton of experience in the state that you're going to. Again, the type of practice, whether it's a single specialty, multi-specialty, hospital-based, or it's locums, that's going to be key, because they're going to have more experience and know what the ins and outs are as far as what's reasonable and what's not within the documentation. And then you want to make sure that you have access to somebody who can provide the data to you, since the data can be hard to come by as far as getting it specific for your situation. When you're going through the review process, we do recommend that you go through and review the entire contract and you call out any areas that you're unclear about. It can be tricky with these because they will reference the section here in the contract, and then they'll tell you to go to this section, and then tell you to go to this section. And so you kind of have a little bit of a rat race as you're trying to pencil your way through the contract. So identify any of those areas that you're unsure about.
23 now. Sepsis alert, emergency room 23
Sorry, you're calling
now.
something overhead.
Okay.
Sepsis
That's
alert, emergency room 23 now.
So get a list of things. You want to make sure you're prepped and ready to go as you go into your meeting with your advisor, your attorney, whoever you have helping you, so that way you can make the time as efficient as possible, especially if you're getting counsel from somebody who does charge by the hour. And that is an issue. Normally, the type of lawyers that you want to have help you with this, they'll charge anywhere from $300 to $500 an hour, and they're going to spend some time reviewing it, consulting with you. There will be some back and forth with the practice usually, and so it can easily add up to $1,500 or more when it's all said and done. There are options that you can use that are flat fee, so that way your expenses are well defined as far as what that total cost will be. So that's going to be key. The big areas that we find that get in the way as your like where conflict pops up is where it's just not clear what the expectations are, or if they're wanting you to do the additional work like we talked about before and they're not compensating for all of it. The directorship can be something where you should expect an additional $25,000, $30,000, or $35,000 depending on what the scope of that is. When you maybe have things that you're going to bring to the table, maybe you have a side business or you have something else you want to do personally that's outside of the scope of your practice, or you have an invention or something that you created, you want to make sure that you have documentation in place so that way it's protected and it's carved out. Most employers are going to want to require you to work for them and exclusively for them and have nothing else outside of that relationship with them. But that might not be what your situation is. You may have other things you want to do, or you may want to pick up some additional shifts with maybe a locum group or something else, or maybe you're working a 7 on, 7 off, and you want to pick up a couple extra days on top of that. You have to make sure on the front end that you have some language in there that provides you some ability to do that. And sometimes the contracts will say that you have to get them to sign off on and approve it. And that might be okay, but it might not be, because what if they say no to you and it's something that you want to do on your own personal time? So those are things that you want to make sure on the front end that you have identified and think about. And even if maybe you don't have something that you want to do at the beginning, but maybe down the road you want to pursue it, you absolutely want to make sure that you create some carve outs for yourself with that. The restrictive covenants piece, you can reduce the amount of time, you can reduce the reach of mileage, and you can reduce the scope sometimes with that. Going back to that question earlier about the signing bonus, sometimes those things are not included and they're easily able to be added. If you have a large health system with a retirement plan, they may offer you a bunch of different things that adds value to your compensation plan versus another practice out there. So that way you may need to address the fact that they don't have a retirement plan, or they don't have a second or third option for you to do some additional tax deductible retirement contributions. So those are all going to be things you want to be mindful of. Again, getting multiple offers and being able to put them side by side. Yes, it's not always going to come down to the numbers and the financial aspects of the offer, but it does make a difference. And you can use those to your advantage when it comes down to getting employers to make adjustments for you. So again, confidence is key. You may have seen statistics around how women are paid less than men. And from my own personal experience, I will tell you that in my experience, I found that women are less willing to push the envelope when it comes to pay and push for asking for things. And because of that, that pops up a lot. And so don't feel like if maybe you're not as comfortable or as confident to do this, that you can't do it. That's why having a third party represent you is helpful. So I think a big reason why there's a discrepancy there is because of that. So utilize the resources to your advantage with that. If you're going to be trying to get the employer to offer you something better, just simply asking for it without backing it up with something tangible or specific to justify why you're asking for it, you're probably not going to see them be willing to respond as favorably. So that's why, again, having multiple offers is key. Having good databases to tap into. There are literally like 12 different sources of information that you can go to get access to information. So it's combining all those together that can be helpful. Any questions on those areas? Okay. Going back to the areas that are more easily able to be negotiated. Anything with pay tends to be the case. Your schedule can be the case. Things like your allowance for CME, your time off for CME, and then going back to, again, the restricted covenants. Those are areas that typically are able to be adjusted. And again, if the employer has a contract that's very one-sided, it might be that you're just going to be the first one to make the asks and pave the way and like kind of be a trailblazer for the employer to get the adjustments made. Too many physicians have just received a contract and then just signed it as is because they were afraid of not wanting to rock the boat, not wanting to send the wrong signal, give them the wrong impression, not make the employer feel like that they're going to be high maintenance, or cause them to potentially lose the offer. We've never lost a contract because we've had the negotiation team involved with trying to get them better terms. So the worst thing that can happen is that you just get what the employer is offering to you and that's it. But in 99% of the cases that we've worked with, we do not see that's what happens. There is a lot of room to see improvements. And again, the employer does not start with their best offer. Rarely is that the case. They're trained. And here's the thing. They're going to tell you that the contract is the same one that everyone else has signed. It's compliant with state laws. It's been vetted by their attorney. and it's not negotiable, they don't make any changes. So think about that. Like, if that's how they present this contract to you, what's your reaction going to be? Probably going to take their word for it, right? But you shouldn't, because again, there's a lot of room here. This will be clearly the first time that you will have access to having some say in what your options are. And so you definitely want to make sure that you have the tools that you need to support your case. So again, wrapping things up, definitely want to make sure it's in writing. Anything they tell you in the interview, if it's not a contract, it doesn't exist. This agreement you sign is like your separation terms at the very beginning of the relationship. Make sure that you have good counsel in place. And then the back and forth, if you request changes and then they respond to them, you want to have the contract in a form that they do redlining. And redlining is where within Microsoft Word, you have the original document, and then when changes are made, it'll highlight what those changes are. You've probably seen that before. It's not unreasonable to ask for that or to have that as the back and forth. And you want to be able to see what these modifications were, so that way, if they said yes, they'll make some changes for you, and then it comes back and it doesn't show that that change was made, then you can catch it a little bit easier. Last thing you want to have happen is that they say yes, they'll do something. You end up signing off on it, and then their intention was that they would make those changes, but they actually don't. And then that person leaves because that turnover is also an issue with administration. And the person that you thought you were going to be working with or for is no longer there. And while they might have been loyal to you and supportive of what the language was going to be upon that request that you made, it doesn't actually make it the contract. And then the employer plays hardball, you could be stuck. So you absolutely want to make sure that you have your ducks in a row with that. You'll see here on this slide, it says beware of the resources. And I say beware of these because these are common things that people will look to, and it ends up selling themselves short a bit, because the AMA was an organization that was a good representation of the industry many years ago, but they're not so much that case anymore. They're trying to get better. They've been making some big changes within to try to represent the larger industry, and unfortunately, they still are only, I don't know, it's like 20% of 25% of the industry they're representing right now. So be careful with that. Medscape and Doximity as online resources, there's usually some free stuff. They're going to give you a generic kind of high level number. They don't necessarily break it down specific enough. So that may not be good enough. And then we talked about the advisory side. Make sure that you have access to both financial and legal counsel as you're getting reviews done, because the lawyer that you use, unless they're in the numbers every single day, they're probably not going to have a good grasp of what your numbers should be for you. So those are some of the areas that you'll want to make sure you're aware of within a contract, how to prepare for it, some things you can do for negotiation, as well as how to tee yourself up. The contract may specify that you have a turnaround time that you need to get back to them by. So you have a limited amount of a window, like a deadline, where they'll want you to respond to them. So make sure you do your research ahead of time, identify what team you want to use. Some places may take longer to get up and running, and there could be an issue with your turnaround time on getting back to the employer. Others may be more quick to get back to you. So just be ready, so that way once you do think you're going to be getting a contract, so that you have those people on standby essentially and are ready to go.
Thank you so much.
Yes, thank you so much. I know our hours have been in here, but we really appreciate your time and everything.
All right, take care.
Questions, anything? Any last comments? You're free to go ahead.
So let me just say the last thing about the LLC piece.
Guys, real quick. Go ahead.
Yeah, LLC, real quick, just to mention that. So you can have an accountant or an attorney draft an LLC for you. You don't technically have to have one if you're a 1099, but it does provide limited liability protection for you, which is key. But then the other piece of this is for tax purposes. You can actually lower your income tax rate by how you file your taxes. So the benefit of having the LLC is really upon how you go through and you file under what's called the S election. You don't have to technically be an S corporation, but by filing as an S election, you can lower your taxes by, it could be $10,000 or more per year. So that's going to be key. But you can reach out to a couple different individuals. Like I said, CPA or an attorney are the two groups that can help you with that. Usually, we also have a bunch of people that we can refer you to if you have questions about it as well.
Thank you.
Thank you so much.
You're welcome.
Appreciate it.
Hey, all right, I'll talk to you later. Bye-bye.
Bye.